that half the number of votes. But I think, Chair, rather than engaging in a lengthy debate on the issue, as the Chair had raised, I feel it's maybe more appropriate for this issue to be deliberated on when we deal with the Muslim Marriages Bill. And if there needs to be a constitutional amendment, we can still effect it at that point. This is a new topic, new area, as it were. If we are going to make provision, as you want us to, for a specialist Muslim divorce court, we would have to throw that open to the public and engage get representations from the entire Muslim community and other people who may be affected indirectly. Thanks, Jim.
Assalamu alaikum. I think I probably have the honor of being your MP, certainly for your headquarters and possibly residentially as well. Your party did not garner enough votes to have representation in the chamber here, so you choose to come under that umbrella. Like the Honourable Jeffries, I would like to know how formal the support that you claim from the MJC is. And I think what one can simply say is this. Mr. Hendricks writes to me quite regularly. We are aware that it has taken many years for the Muslim Marriages Bill to come before the Justice Committee. It is on our list. Our workload is very great. We may not get to it this year, but it is firmly on our list. And we will deal with it. And at that time, we will take all of the views from the Muslim community, including those of women, because it is our constitutional duty to try to give effect to religious rights as well as rights to equality of every other constitutional right that is enshrined. It is going to be a challenging exercise. It will be our honor to pass that law, because it is long overdue that Muslim marriages should be recognized. It is intolerable that they are not. But you are so putting the cart before the horse by claiming here, you go very far. You are actually asking for substantive constitutional changes. And those can only be contemplated after we have done that bill. And you are putting the cart, with respect, before the horse. The whole tendency of the Superior Court's bill is to recognize separate courts. So I don't see that there's a problem. But in the meantime, we can't anticipate any kind of a view on whether there should be such a court or not. So with the greatest of respect to you, we look forward to seeing you when we deal with the Muslim Marriages Bill, and that will be the appropriate time to hear the many voices from the Muslim community. Thank you.
Thank you, Mr. Chairman. I endorse completely and subscribe to what the Honourable Jeffrey said. With perhaps one exception and one qualification or addition. An issue of this nature carries its importance whether it affects and is felt by 100 people, 100,000 people, because it's a human rights issue. The qualification addition that I wish to make is that there is a differentiation between the Marriage Act and the marriage relationship. We passed a Marriage Act for Home Affairs, which deals with all types of marriages. At the time, we engaged Darla Omar and DDG Leon Radman, who is here today, to try to combine the Marriage Act with the marriage relationship. And it was extraordinarily difficult, because marriage relations, in recognition of the substantive law of an Islamic marriage, created a number of problems. So the definition of the marriage relationship and the substantive law would precede the establishment of a court. I think it's very problematic to give a recognition to the substantive law by means of establishing a court, which effectively tells us what the law is. Courts should apply the law, should not make or recognize the law. So the great challenge is to deal with the Marriage Act, with the marriage relation, revised to identify the rights and obligations within marriages, not only for the Islamic community, but also for other communities where the marriage relationship is regulated in terms of undefined and not written down of indigenous and customary law. And that applies to traditional courts as well. It's a great It's a great challenge. You have the same differentiation, for instance, within the Roman Catholic system. The Sacra Rota is a specialized entity which is legal recognition only for the Marriage Act, the marriage law, the substantive aspect, the marriage relationship stays with the law of the land.
Thank you very much. I'm actually covered by Jeffries and the Armstrongs.
Yeah, thank you for the opportunity to respond, Mr. Chairman. The question was asked, how formal was our approach to the MJC? I had the opportunity to be briefed on the Superior Court's bill by a present judge of the Labour Court. And after that, I did a presentation to the Muslim Judicial Council on the Superior Court's bill. And I gave them a copy of the bill. And they gave us a letter of support, and they sent a letter to the Department of Justice telling them that they support the specialist court, which, like I said earlier on, was in the previous version of this bill. And they support a separate court to judge Muslim marriages. And the reason for this, Mr. Chairman, which came out of the meeting, is that the Muslim marriages bill, when it comes to jurisdiction, indicates that jurisdiction will be in the hands of the High Court. And one can just imagine the difficulty later on when this is addressed. Now that we're dealing with the Superior Court's bill, we feel that there should be space in addition to the High Court for a separate or a specialist division of the High Court, so that the marriage bill, for example, could then state that jurisdiction will be, if this Parliament approves, a separate court, as recommended by the South African Law Reform Commission. It will then state that jurisdiction will be in the hands of the separate court. So I'm not sure whether the honourable members are being fair to say that we are jumping the gun. We've been invited here to have our say. And, Mr. Chairman, the reference to the Muslim marriages bill is very sad, because the Muslim community, the senior religious leaders in the Muslim community at this point in time do not agree on even one provision in that Muslim marriages bill. Not one provision, Mr. Chairman. So it is going to be a very contentious way forward. Now, my dignity, Mr. Chairman, has been harmed from the cradle to the grave. When I was born in a Muslim compliant marriage, I was considered illegitimate. If I die, Mr. Chairman, my birth certificate will say never married. So my dignity is harmed from the cradle to the grave. And I can't understand, Mr. Chairman, how the honourable members here can deny us taking the first steps to restore some of that dignity, Mr. Chairman. The issue of support, Mr. Chairman, I indicated earlier on that the Muslim Judicial Council, they've supported a separate court. The Majlis Ashura al-Islami, who is the other religious group in Cape Town, they supported. They've also sent a formal submission to the Department of Justice and Constitutional Development in this regard. So it is on the record, Mr. Chairman, and if necessary we can produce these documents. We have, in the Friday sermons over the past 2 years, we've engaged the communities with regard to the separate court, all endorsing the position of the South African Law Reform Commission. So we feel, Mr. Chairman, that it took so long for the Superior Court's bill to reach this stage, and the name has changed from time to time. It's not easy, Mr. Chairman, to introduce constitutional amendments. Now the Superior Court's bill is finally going to go before Parliament for its approval. We feel as a Muslim community, because of the injustice done to us over 300 years and in the last 17, 18 years, that this portfolio committee must seriously consider creating the space for a separate court or a specialist court. So later on, when we deal with the Muslim Marriages Bill, if it ever reaches this portfolio committee, Mr. Chairman, I don't think it will reach it in my lifetime, Mr. Chairman. But if it does, then at least one of the jurisdiction issue will then be sorted out, that the Superior Court's bill has provided for a separate court. We made reference to the fact that our constitution is flawed in that it's not very serious about religious freedom. It's a personal view, Mr. Chairman. It does refer to religious freedom. It goes further to identify a very important matter for most religions, and that is the issue of family life and marriage. So marriage is specifically highlighted. So you can't blame us, Mr. Chairman, if we pick on this aspect of religious freedom and ask you to re-look at the Constitution and in the preamble of the Superior Court's bill. And maybe it should be somewhere in the Constitution as well, that when it comes to marriages, because this is highlighted in our own Constitution, the family laws of religions should trump the provisions of the Constitution, Mr. Chairman. I don't want to take the time of this portfolio committee. But for example, there are competing positions with regard to gender equality and religious freedom. What is more important, religious freedom or gender equality? It is our view, Mr. Chairman, that lawmakers should not dabble in ecclesiastical matters and should leave it to religious communities to practice their family life and their marriage laws according to their scriptures and according to their holy texts. And if the holy text differs with the Constitution, like you know it will differ when it comes to gender issues as far as the Muslim community is concerned, then the religious doctrine and text should trump the Constitution. The Constitution speaks about reasonable accommodation in this regard. We want to go one step further, and that's why we've suggested a change to the preamble in the Superior Court's bill, Mr. Chairman, which I'm sure you all have read, but it basically comes down to the fact that lawmakers mustn't dabble in ecclesiastical matters, and that communities should be allowed to practice their religion, especially their family life, Mr. Chairman. And that is all that we are asking for, is for the Superior Court's bill to take account of the needs of all the communities in South Africa. The Superior Court's bill wasn't there to put more money and more tenure in the pockets of judges, Mr. Chairman. That shouldn't occupy a lot of our time.